Good morning, sir. Can you see and hear me?
Yes, I can, thank you.
Thank you very much. May I call John Scott?
Yes.
If you repeat after me, I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you.
Good morning, Mr. Scott. As you know, my name is Jason Beer and I ask questions on behalf of the inquiry. Can you tell us your full name, please?
John Michael Scott.
Thank you very much for coming to assist the inquiry in its work and for previously providing 2 witness statements to the inquiry. We're very grateful. Before I ask you questions about your witness statements, I think the chairman will deliver a warning.
Mr. Beer, can you tell me whether Mr. Scott is legally represented this morning
Yes, he is.
by a solicitor and counsel or just solicitor?
Both.
Thank you. Mr. Scott, a witness at a public inquiry has the right to decline to answer a question put to him by counsel to the inquiry, by any recognised legal representative, or by me, if there is a risk that the answer to that question would incriminate the witness. This principle of our law is known in shorthand form as the privilege against self-incrimination. I have decided, Mr. Scott, that fairness demands that I remind you of that principle before you give your evidence. However, I should also tell you that it is for you to make clear to me that in respect of any question put to you, it is your wish to rely upon the privilege. If therefore any questions are put to you by any of the lawyers who asks you questions, or by me, which you do not wish to answer, on the ground that the answer to such questions might incriminate you, you must tell me immediately after the question is put to you. At that point, I will consider your objection and thereafter rule upon whether you should answer the question or whether the objection should be upheld. As you've just heard me inquire, you are represented here today by counsel and a solicitor. No doubt if the issue relating to self-incrimination arises, they will assist you, and if at any stage during the questioning you wish to consult your lawyers about the privilege, you must tell me so that I can consider whether that is appropriate. Do you understand what I've just sought to explain to you, Mr. Scott?
Yes.
Thank you very much. Then please begin the questioning, Mr. Beer.
Thank you very much, sir. Mr. Scott, you should have in front of you a hard copy of a witness statement in your name and dated the 12th of May 2023. If you turn to the last page of it, which should be page 47, there should be a signature. Is that your signature?
Yes.
With the corrections that you subsequently made in your second witness statement, more of which in a moment, are the contents of that first statement true to the best of your knowledge and belief?
Yes.
Thank you. For the purposes of the transcript, the URN for that first witness statement is WITN 0389 0100. There's no need to display that at the moment. You produced a second witness statement of your own volition yesterday, and there should be a hard copy of that in front of you. Is that right?
That's correct, yes.
And if you go to, I think it's the 9th page. Is that right?
Page 10, yes.
10, in fact. Okay. Is that your signature?
Yes.
And are the contents of that witness statement true to the best of your knowledge and belief?
Yes.
The URM for that is WITN 0839 0200. Again, there's no need to display it. Can I start, please, with your career qualifications and experience? I think it's right, isn't it, that you were employed by the Post Office and cognate organisations between February 1993 and September 2016, is that right?
Yes.
And so for 23 and a half years.
Yes.
If we go to your first witness statement, please, so WITN 08390100. It'll come up on the screen for you. Thank you, and go to page 2. And look under the heading background at paragraph 5. Under the heading background, you tell us, quote, I have an MSc in security and risk management, focusing on preventative security and criminology. I also have other supporting industry qualifications, such as a diploma in anti-money laundering. Is that right?
Yes.
I think it's also right that you are a former police officer.
Yes.
Can you tell us how long you served in the police service for?
About 7 years.
And between what years was that?
1984 to 1992.
84 to 92.
Yes.
Thank you very much. And were you a uniformed officer or a detective?
The vast majority uniform, a very small part as a detective for about 3 months.
And what rank were you when you left?
Sergeant.
Were you trained in and did you operate under the Police and Criminal Evidence Act 1984?
Yes.
Did you construct files for advice to be given on charging decisions?
I submitted files to the CPS, yes.
I'm sorry?
I submitted files to the CPS.
Yes, and so you put files up to the CPS to make charging decisions, is that right?
Yes.
Did you ever make decisions about charging suspects with offences yourself?
Not that I recall, no.
Were you familiar with the terms of an operation of the Code for Crown Prosecutors?
At that time, I can't recall, to be honest.
You tell us in this statement here your background, and you tell us about your MSc in Security and Risk Management. You don't mention here that you were a police officer. Was there any reason for that?
No, not really. It's we got a significant amount of documentation and pages with a very limited time in which to respond to lots of questions. So it was a challenge just to get the statement in, to be honest.
Did the documents that we sent you assist you to remember whether or not you were a police officer?
I knew I was a police officer.
So I'm asking you, in your background here, you tell us about your MSc. Mm-hmm. You don't tell us about you being a police officer.
My MSc was done during the post office period. They sponsored it, and it's around the preventative, which was the strategy that I was taking within the post office.
You knew that in the questions we were asking you to create the witness statement, you were being asked questions about adherence to the law concerning the conduct of criminal investigations and prosecutions, didn't you? That's what the request was all about.
Okay, I understand.
Did you not think it was relevant to say that you were a police officer?
As I say, it was a challenging time to get the statement in and read all the documents.
So it was the volume of documents that meant that you didn't include the fact that you were a police officer?
I have to say, I can't recall at that time trying to get the statement in, to be honest, in a challenging time.
You were, you held various roles in the security team in the post office between joining in 1997 and 2004, is that right?
Yes.
And from 1999 to 2004, you were head of security for Royal Mail International, is that right?
Yes.
What were the primary responsibilities of that job?
It was all preventative around the theft or loss of international mail.
Were you aware in that period of time of the development of the Horizon system?
No.
So in the 5-year period between 1999 and 2004, you had not heard of Horizon, is that right?
As far as I recall, no.
And so you weren't aware that the Benefits Agency had been involved in the project and had withdrawn from it?
No.
And you weren't aware of any what were described as acceptance issues, i.e., in high-level summary, whether the Horizon system was performing as expected or not during the development of Horizon?
No.
You weren't aware of issues that arose concerning the reliability and accuracy of the data that Horizon produced during the rollout of Horizon?
No.
You wouldn't have been aware that the rollout of Horizon had to be paused?
No.
Nor the reasons why rollout had to be paused?
No.
From 2004 to 2007, you were the security manager, the senior security manager for physical security, is that right?
For the Post Office, yes.
And were you required to perform tasks in that role that required an understanding of how Horizon functioned in branches?
Very limited for Christmas duty.
Can you explain, please?
So all employees would support the branch network at Crown offices and would go onto the counter and do the very most basic of services like selling stamps.
So it was just a knowledge sufficient to work at a temporary cover level at Christmas?
Even more limited than that, because it is very basic products we would have been selling.
Sorry, if you just keep your voice up, it was very basic products?
Such as selling stamps. It wasn't even extended past those sort of areas, very basic products.
Between 2004 and 2007, did you receive any training on the use of Horizon?
And to do that, it would have probably been a 1-day training course to sell those basic products.
And a 1-day training course once, not each year?
Once.
Did you receive any refresher training?
Not that I recall.
In that period up until 2007, i.e. until you became head of security, had you heard of any issues with the integrity of Horizon or the reliability and accuracy of the data that it produced?
No.
From 2007 onwards, you became head of security, is that right?
Yes.
And you took over from Tony Marsh?
Yes.
And Mr. Marsh moved to be in charge of security at the Royal Mail Group, is that right?
Yes.
You hesitated?
No, he did go to the Royal Mail Group as head of security, and then it evolved a little bit after that, I think.
Tell us about the evolution.
The security director, or group security director, left around about 2008, and he took on that role as well as the director of his existing role. So it merged two roles.
So he didn't move to Royal Mail Group to be the head of security. He moved for another role and then a year later also took over that role.
No, he did go over to be the head of security or director of security for Royal Mail Letters. And then when the Royal Mail Group director left, he took on that role as well as the Royal Mail Letter role.
Was there any chain of responsibility between you and Mr. Marsh after Mr. Marsh moved to the Royal Mail Group?
Once he took over the group security director, yes, there was a dotted line.
And what did the dotted line consist of?
He was the group security director responsible for security across all business units within the Royal Mail Group.
And so, for example, how often would you meet or otherwise communicate?
I do recall going and meeting him 2 or 3 times in the first 18 months or a couple of years, and less so thereafter.
And if you can tell us more about what a dotted line means. Was he responsible in any way for your management or supervision?
Day to day, that's a responsibility of Post Office line management. He was responsible more for the security and the security requirements across the business.
What does that mean? He was responsible for the security requirements across the business, insofar as that concerned you?
So he had overall oversight of the security within the Post Office, the strategy, the direction, what we're delivering to, our performance, etc.
And so would you say he had oversight of the discharge of the responsibilities of the security department within Post Office, including its leadership by you?
I guess so, yes.
We've heard from Mr. Marsh. It's the transcript for the 5th of July 2023, page 213, line 30, and on to page 214, that he did not enjoy a good working relationship between you. He said it wasn't a great working relationship and it wasn't a good working relationship. First, is that right?
We had a good working relationship up until a certain point around about 2008, and thereafter it was a bit more of a distant relationship.
Why was it a bit more of a distant relationship?
There was a complete disagreement in terms of strategy around investigation and prosecution.
Was it a personality issue between the pair of you?
No.
But what was the nature of the disagreement then?
I'd taken over as head of security for the Post Office. The investigation team, which I created into the fraud strand, was very much focused on purely investigation and prosecution, whereas I wanted to take a very much more preventative approach. So to deter, to prevent, to disrupt, and then if necessary, investigate and prosecute. And that approach took an analytical approach where we did a root cause in terms of the MI on all the different products. We'd see where we were getting our largest losses, or we were repeating the same type of investigations and prosecutions. And I wanted to do a more preventative, stop it at the outset, whether it's fraud or non-compliance, rather than just keep on investigating and prosecuting. As such, the analysts would then draw up the outliers so we could see a branch profile, and it was not within the sort of the boundaries of what all the other profiles of that post office are. It was an outlier, and that could be 1 to 50, 1 to 100 post offices, and rather than investigating and looking to prosecute out all those outliers, I took a preventative approach. So we did letters out to them, we'd done phone calls, we offered training, etc. And his was very much, he wanted every single one investigated and, if necessary or appropriate, prosecuted.
And how did he make this clear to you, that he wanted everyone investigated and, if appropriate, prosecuted?
I can't recall the discussions that we had when I went to meet him, but ultimately he left me a message to say that as Group Security Director, he was going to take over the investigation team as from the following week and have it reporting into his head of criminal investigations.
If you didn't do what he said?
No, it was...
In any event?
He was going to do that in an event.
And did that happen?
No.
Why didn't it happen?
I reported it to my line manager.
Which was who?
I believe it was Mike Young at that time, but it is only, I believe, it could have been Rick Francis, but I believe it was Mike Young.
And sorry, I interrupted you. You reported it to Mike Young and?
Obviously, I think there was conversations more senior. Then I was required to write a report on the reason and rationale of the strategy. I think I got the head of fraud to write that. That was submitted to Mike Young, and I understand the MD, Alan Cook, had conversations with his senior executives in Royal Mail Group, and then it came back to say I can continue with the prevention approach.
And so would that be from about 2008 onwards?
2008, 2009, I can't actually be precise.
Had you encountered any difficulties with Mr. Marsh before he moved on to the Royal Mail Group?
No, he was my line manager for 3 years before that.
And did you enjoy a good working relationship with him then?
Yes.
In any event, you assumed the role of the Post Office's head of security in 2007, and you stayed in that position until you left the organisation in 2016, is that right?
Yes.
And therefore you were accordingly head of security during one of the heaviest periods of sub-postmaster prosecutions. You know that now.
I'll accept that.
And you presided over the cessation of prosecutions from 2014 onwards.
I thought it was 2013, but if
But
it's
it's the last months of 2013.
Yes.
What was the driver for the change of policy?
Because the subject matter expertise within Fujitsu had been discredited apparently by the information that he'd been given, the evidence he'd been given, and Cartwright King said he cannot be used, and therefore the Post Office needed to find another subject matter expert to support any evidence.
Could you find another subject matter expert to support reliance on the Horizon system?
By the time I left the Post Office, which is in 2016, no.
So no expert could be found in 3 years or so to support the reliability of Horizon. Is that right?
No, I wasn't really involved in those discussions, so I'm not too sure what was in the background, but as far as I'm aware, no.
You were the head of security, the department responsible for investigating and submitting files for prosecution, and in your case, making decisions on prosecutions.
For a short period of time, yes, I made decisions on prosecution.
You must know, therefore, what was done in order to find an expert to speak to the reliability and integrity of Horizon, mustn't you?
Sorry, can you repeat that?
Yeah, you must know, therefore, as head of security with those responsibilities, what was done to find an expert witness who could speak to the reliability and integrity of Horizon.
I was aware that there were inquiries going on. I only recall being in one meeting with an external potential SME.
Who was the potential external?
It was a London university. I don't know which one.
Were they prepared to give expert evidence standing up the reliability of Horizon?
It was an early meeting, and I don't think it was progressed thereafter.
So the reason for the cessation of prosecutions was twofold. Is this right, on your recollection? Firstly, the subject matter expert from Fujitsu had been discredited, according to advice given by Cartwright King. A new expert was needed, but none could be found.
Correct.
And I think you retired in 2016, or you left the Post Office in 2016, the year the group litigation was launched and a claim was issued. Did you know about that before you left?
Not that I recall, no.
Did you retire then, or did you move on to another job?
Moved on.
Was there any relationship between the commencement of the group litigation in 2016 concerning the Horizon system and the data that it produced being used for prosecutions and you leaving the Post Office?
No.
They were entirely unconnected events.
Yes.
Can I turn to start asking you about the substance of issues? by looking at an issue which arises towards the end of the era of private prosecutions. So it's therefore out of turn in the chronology. I want to start with it to work out whether it tells us anything about the values of the investigation and prosecution functions of the Post Office more generally in the earlier period. And the topic is the recording of information and the disclosure of material in criminal proceedings. Okay. I'm going to deal with matters chronologically within this topic to give you some context. We're in the year 2013, which, right at the end of which the prosecution function, as we've discussed, came to an end, okay? Can we start by looking at something which happened on the 3rd of July 2013? Do you remember a man called Simon Clark?
Yes,
What do you recall about him?
he was a lawyer with Cartwright King.
So he was an in-house barrister, do you remember, at the solicitor's firm Cartwright King?
When you say in-house, for us, he was an external lawyer.
Yes, he was a barrister in Cartwright King, or did you just know him as a lawyer?
Lawyer.
Okay. Did you enjoy a working relationship with him?
I don't recall actually having a working relationship with him. I may have met him once or twice, but there wasn't a working relationship. There was nothing.
Cartwright King were the firm of choice for the conduct of private prosecutions, is that right, for the Post Office?
Yes,
And was that for the entirety of the period up until now when you were the head of security, so from 2007 to 2013?
I only recall them round about separation, either at separation or just prior to separation.
I.e. from 2011 onwards, is that right?
Well, separation was 2012, so it was either just before that or around that time.
In any event, on the 3rd of July 2013, Mr. Clark attended a conference at Post Office headquarters to consider issues relating to the reliability of the Horizon system and the prosecution of sub-postmasters for criminal offences. Now, there's no note that we have of this meeting of the 3rd of July 2013, but the advice that he gave at that meeting is addressed in a later advice that he wrote, which is dated the 2nd of August. Could we look at that first, please? It's poll 406799. So this is an advice dated the 2nd of August 2013, take it from me rather than looking at the end of the document. And can we just read paragraphs 1 and 2 together? He says, on the 3rd of July 2013, I attended the Post Office in conference at Post Office Head Office to consider issues relating to the Horizon computer system and the prosecution of criminal offences committed against Post Office by sub-postmasters and clerks. One of the topics considered by the conference was that of disclosure. I advised that there ought to be a single central hub, the function of which was to act as the primary repository for all Horizon-related issues. The hub would collate from all sources into one location all Horizon-related defects, bugs, complaints, and queries and Fujitsu remedies, thereby providing a future expert witness and those charged with disclosure duties with recourse to a single information point where all Horizon issues could be identified and considered. The rationale behind this advice derived from the need to protect the Post Office from the current situation repeating itself in future. Did you attend that conference, the 3rd of July 2013 conference?
I don't recall attending.
And that answer, I don't recall, is capable of a wide range of possibilities. including, it's very likely that I did attend, but I've got no present recollection, it being 10 years on, that I did, right down to, I don't think that I did. If I had attended, I would remember it, albeit I've got no present recollection. Where in the spectrum are
The
we?
latter,
Okay. You don't think that you did?
correct.
Do you recognise what is said there, the need to create a single central hub to collate from a range of sources information about defects, bugs, complaints, queries and remedies?
Yes,
And so one way or another, you were told about the need to create this hub. Is that right?
I was told, I'm not necessarily say I was perhaps fully briefed in terms of its requirements.
You said that you were told but not necessarily fully briefed.
I don't recall getting a real briefing in terms of the requirements of setting up the weekly meetings.
Moving on to paragraph 3, he says, the Post Office accepted that advice and accordingly a weekly conference call meeting was established so as to meet the requirement of the central hub. Participants were informed that they should bring all Horizon-related issues that they had encountered to the meeting, and then over the page, minutes were to be taken, centrally retained and disseminated to those who required the information. This list to include Post Office's Horizon expert witness. Is the first part of that paragraph correct, going back to the bottom of page 1? Accordingly, a weekly conference call meeting was established so as to meet the requirement of the central hub.
Yes,
Can we go on to paragraph 4? 3 such conference calls were convened, each conducted on a Wednesday morning. A representative from Cartwright King Solicitors attended each meeting. A minute taker was appointed for each call, and I understand that each of the minute takers retained their own handwritten minutes. We'll come back to all of that in a moment. Can we move forwards, please, to the 15th of July, please? That's poll 406357. If we go to the last page, please, which is page 14. Let's scroll down, please. You'll see that it's dated the 15th of July, 2013. This is known as the first clerk advice, yes? And if we go back to the first page, please. Look at the first paragraph. Mr. Clark says, I'm asked to advise the Post Office on the use of expert evidence in support of prosecutions of allegedly criminal conduct committed by those involved in the delivery of Post Office services to the public through Post Office sub-Post Office branches. By and large, these allegations relate to misconduct said to have been committed by sub-postmasters and or their clerks. This document considers the provision and use of such evidence in past prosecutions and those currently underway. He will deal with future prosecutions separately. Did you receive a copy of this advice?
I don't believe I did.
Were you told about the contents of it?
I don't believe I did.
Can we look, please, at page 13, paragraph 38 and following? 30, yes, page 13, thank you. I'm not going to go through the entirety of the advice, but just go to Mr. Clark's conclusions. I'm going to replace where Mr. Clark says doctor or uses the word Jennings with Mr. Jenkins. The reasons as to why Mr. Jenkins failed to comply with this duty are beyond the scope of this review. The effects of that failure, however, must be considered. I advise the following to be the position. Mr. Jenkins failed to disclose material known to him, but which undermines his expert opinion. This failure is in plain breach of his duty as an expert witness. Accordingly, Mr. Jenkins' credibility as an expert witness is fatally undermined. He should not be asked to provide expert evidence in any current or future prosecution. Similarly, in those current and ongoing cases where Mr. Jenkins has provided an expert witness statement, he should not be called upon to, over the page, give that evidence. Rather, we should seek a different independent expert to fulfill that role. Notwithstanding that the failure is that of Mr. Jenkins and arguably of Fujitsu Services Limited being his employer, this failure has a profound effect on the Post Office and Post Office prosecutions, not least by reason of Mr. Jenkins' failure. Material which should have been disclosed to defendants was not disclosed, thereby placing the Post Office in breach of their duty as a prosecutor. By reason of that failure to disclose, there are now a number of convicted defendants to whom the existence of bugs should have been disclosed but was not. Those defendants remain entitled to have disclosure of that material, notwithstanding their now convicted status. I've already advised on the need to conduct a review of all Post Office prosecutions so as to identify those who ought to have had the material disclosed to them. The review is presently underway. Further, there are a number of current cases where there has been no disclosure where there ought to have been. Here we must disclose the existence of the bugs to those defendants where the test for disclosure is met. Where a convicted defendant or his lawyers consider that the failure to disclose the material reveals an arguable ground of appeal, he may seek the leave of the Court of Appeal to challenge his conviction. In an appropriate case, the Court of Appeal will consider whether or not any conviction is unsafe. In doing so, they may well inquire into the reasons for Mr. Jenkins' failure to refer to the existence of bugs in his expert witness statements and evidence. Out of that, how much were you told?
I don't recall being told that.
You were told none of this.
I don't recall seeing this document.
That's a different question to whether you saw the document. You've already said that you don't recall being seen it, to how much of what is written there you were told.
The only thing I remember being told was that he couldn't be used because he's no longer he's a discredited witness.
So you were told the bit about Mr. Jenkins being a discredited witness. Were you told the bit, and I'm summarising, about that fact calling into question the safety of past convictions?
I don't recall that.
Who told you that Mr. Jenkins was a discredited witness?
I suspect that would have been my line manager, Susan Crichton.
Susan Crichton? Mm-hmm. And did you mention it in a meeting or in passing?
I can't recall. I think it was probably more than once it was discussed.
Did you say why? What's Mr. Jenkins done wrong?
I suspect I did ask. I can't particularly recall.
Did you think, well, hold on, if he's a discredited witness, he's given evidence in a number of prosecutions for which my department is responsible?
So I do recall the solicitors discussing it in terms of reviewing the cases, and I believe they reviewed the cases going back a number of years.
Did you ask to see the advice?
I don't believe I knew the advice was there.
So you're the head of security, responsible for nearly a decade for the prosecution of sub-postmasters. Your department carries out that functions, and you neither saw this document nor had its contents explained to you. Is that right?
That's what I believe, yes.
Whose responsibility would it be to show you this document?
That would be my line manager, Susan Crichton.
Do you agree, looking at it now, that you should have been shown it?
Yes.
And why do you think you should have been shown it?
because obviously my team was responsible for investigations and submitting case files to the lawyers.
And you yourself have made a number of decisions to prosecute.
Yes.
That can come down, thank you. The next step is the 19th of July 2013. And you'll recall that in the second Clark advice, the one that we looked at first, Mr. Clark had advised the setting up of a single central hub, that the Post Office had accepted that advice, and accordingly a weekly conference call was established, and you've agreed that that is accurate.
Yes.
Now, the first hub meeting was on the 19th of July 2013. Can we look at that, please? Poll 308 3932. Can you see this is a note of what's described as a regular call re Horizon issues on the 19th of July 2013?
Yes.
Now, I don't think you're listed as being in attendance, is that right?
Yes.
Can you see under security, Dave Posnett and Rob King are listed as being in attendance? I think this was a telephone call rather than an in-person call, is that right?
I can see their names. I don't know whether it's a telephone call in person.
Can you tell us at this time, so July of 13, the function that Rob King performed?
He was the senior security manager, or otherwise head of security operations, which covered the fraud and prosecutions.
And so was he a deputy to you?
No, the way that I structured the department was that there were 5 strands, each with their own security discipline, and he was the head of the what was originally the fraud strand, but merged with another to become the security operations. So I had 5 direct reports, all head of their own respective security disciplines.
Did he report to you?
Yes.
So you were his line manager?
Yes.
Looking back now, do you think you sent him along as essentially your deputy for this meeting?
Deputy, I'd say I'd probably asked him to actually take the lead rather than actually deputise for me.
So you asked him to conduct the meeting?
Mm-hmm.
Is that right?
I believe so from looking at the documentation.
You tell us in your new witness statement, the one that you filed yesterday, that you think you delegated the task to Rob King of chairing the meeting. Is that right?
Yes.
If we scroll through the minute, please. Stop there. Outline the purpose of the meeting to identify any issues around the integrity of Horizon from a technical perspective and take any necessary action. Does that describe, as you understand it, the functional purpose of the meeting?
Yes.
It says a process needs to be set up within each directorate where each representative proactively seeks out any technically with Horizon. No minutes circulated, but we will be taking notes. In scope were issues and problems the group were made aware of. As to the line, no minutes circulated, but we will be taking notes, said by or attributed to Rob King, had you given any instruction or direction that no minutes of the meeting were to be circulated?
So looking at the documentation that's been sent to me and the email exchange between myself and Susan Crichton.
That's on the 13th and 14th of August.
Yes.
We're going to come to that in a moment, yeah.
And therefore, based on that document, I was given a brief by Susan Crichton, which appears therefore to have fed down into Rob King through me.
So the answer is yes, you did say that minutes would not be circulated, but that's because Susan Crichton told you that that was what was to happen.
Yes.
Is that right?
Yes.
Were you merely the conduit for Susan Crichton's orders then?
Yes.
You were just following orders?
Looking at the document, that's how I received the brief, and that's how I briefed Rob King.
Then the part of the sentence, but we will be taking notes, i.e. security will be taking notes. Is that how you would understand it?
Yes.
And was that part of the order that you passed on, that it would be the security department that would be taking notes?
Yes. Looking at the email exchange, it was clear that I wanted notes taken.
If we carry on scrolling through the document, please, and then stop there. Under Martin Smith, do you remember who Martin Smith was?
Yes.
Who was Martin Smith?
Lawyer, Cartwright King.
He was a solicitor at Cartwright King, yes. He, in the second part of the note that is attributed to him, says clarification on disclosure and email correspondence. Then in a sentence that it is difficult perhaps to decipher, emphasise need to ensure that any document produced would be potentially disclosable. Do you remember giving any instructions along those lines?
I don't recall.
Would you understand this to mean that this is simply recording the fact that if a document is produced, it needs to be retained so that it can be disclosed?
Yes.
And there's nothing wrong with that?
Doesn't look wrong. Doesn't say what if you don't write it down, but doesn't look wrong.
Yes, it's saying if any document is produced, one reading of it is there is a need to ensure that it is retained so that it's disclosable.
Mm-hmm.
Mr. Posnett makes a contribution, and Andrew Parsons then speaks. Who was Andrew Parsons?
Lawyer with Bond Dickinson.
Did you at this time have any dealings with Bond Dickinson?
I don't recall particularly at that time, but there may have been engagement at some point over the years. There was a couple of occasions where I dealt with Bond Dickinson, but very rarely.
Anyway, the solicitor from Bond Dickinson says there was a need to limit public debate on the Horizon issue, as this might have a detrimental impact on future litigation. Then if we scroll on, please. And keep going. And keep going. And keep going. And keep going. Thank you. And keep going. And then if we go stop at Mr. Parsons again, Mr. Parsons is recorded as saying in the second part of this paragraph that he spoke about emails, written communications, etc. If it's produced, then it's available for disclosure. If it's not, then technically it isn't. What do you understand that to mean?
The way that it's written there, that if something's written down, it's definitely disclosable, but if something's not, then, as he says, technically it isn't.
Is that a view to which you would subscribe?
No,
Why not?
because everything would need to be disclosable.
Was it fed back to you that Mr. Parsons had given this advice at this meeting?
I don't recall.
Can we move forwards, please, to the 24th of July, the next meeting, the second hub meeting. The reference for that is poll 308 3933. Thank you. So we can see similar format. Regular call re-horizon issues meeting on the 24th of July. And we can see that you're not recorded as being present. But from security, there's Mr. King again and Andrew Wise. Who was Andrew Wise?
Security manager within the security operations team investigation.
Again, we can see that Mr. King starts the meeting off. And again, was it your understanding that he was essentially chairing the meeting?
Yes.
And was he reporting back to you what was happening at each meeting?
From the email exchange with Susan Crichton, it says I was being debriefed.
You were being briefed about it?
Yes.
Again, in the second paragraph there, Mr. King is recorded as saying, no minutes circulated, but we will be taking notes. In scope were issues and problems the group were made aware of. So that's materially the same as the warning given at the beginning of the first meeting, yes?
Yes.
And again, does that reflect the instruction that you gave to Mr. King, passing on what Susan Crichton had told you to tell the meeting?
Yes.
Can we move forward to the 31st of July, please? Poll 2013 9732. So this is the date of the third hub meeting on the 31st of July 2013. We can see that, again, you're not recorded as being present or joining the call. It's Mr. King and Mr. Posnett representing the security department. And Mr. Posnett is opening the meeting. Does that mean by this time Mr. Posnett had been put in charge of chairing the meeting?
No, it would be Rob King.
He remained the chair or the leader of the meeting, is that right, to your knowledge?
Until mid-August.
When you took over?
Yes.
And again, you're not in attendance. I don't think there's the warning at the beginning there. Can we move forwards, please, to the 31st of July 2013? That's poll 2013 9745. This is an attendance note dated the 1st of August 2013. Written, we understand it, by Martin Smith, who is whose name is in the top right-hand corner. Can you see that?
Yes.
In relation to a call that he had with you the day before, the 31st of July 2013. And can you see under detail, it says TC, which may be telephone call, JS, which I presume is you, at 6 p.m. on the 31st of July 2013, discussing disclosure issues. J. Scott has instructed that type minutes be scrapped. First off, is that a call with you or is it a call with Jarnail Singh?
I don't recall, but my belief will be it wasn't with me.
Why is it your belief that it was not with you?
Because I don't recall having a relationship like that with Cartwright King at that stage, because it's very early on, but it's not to say I didn't have the call with them. but I don't believe it would have been me.
And you'll see that the way that Mr. Smith wrote his attendance note is one person is referred to as JS. Can you see that in both the summary and in the detail?
Yes,
And the other person is referred to as J. Scott.
yes.
Or- Let's assume for the moment that this is Mr. Smith speaking to Jarnail Singh at 6 p.m. on the 31st of July, 2013, and was telling Mr. Smith that you, J. Scott, had instructed type minutes to be scrapped. Did you give an instruction that type minutes would be scrapped?
I do not recall what I said or how I said it or in what clunky way. Or
Did you say in what clunky way?
Yeah, or how it was interpreted. But I don't recall asking for any minutes to be scrapped. Scrapped is not a word I would particularly use to destroy or delete minutes. It's scrapped is more like a process. I scrap a process going forward.
You said in that sentence whatever clunky words you use. Why would you assume that you spoke in a clunky way rather than in a clear way?
I have no idea. But I would not go around asking for things to be destroyed or deleted. That's just not me.
We've seen that in the typewritten minutes of the meeting, there was an instruction that minutes were not to be circulated, but the security department were going to keep their own notes. That was the instruction that you had given, passing it on from Susan Crichton. Yes?
Yes?
And so if typewritten minutes were in fact being kept, as we've seen they were, that would be contrary to the instruction that you had given, wouldn't it?
Sorry, say that one again.
Yeah. You told us, and it's reflected in that two of the first three sets of minutes, that the instruction that you passed on from Susan Crichton was that minutes were not going to be circulated, but that the security department were going to keep their own notes.
Correct.
We've seen that typewritten minutes were in fact being kept. We've just looked at 3 lots of them, haven't we?
Correct.
That would be contrary to the instruction that you gave, wouldn't it?
I'm a bit lost on the point.
If the security department were going to keep their own notes,
Yes?
and somebody else had in fact been keeping a typewritten version of what had happened at the meeting, i.e. the 3 documents we've just looked at, that would be contrary to the instruction that you had given, wouldn't it?
Yes, in principle, yes.
And therefore, if it was contrary to the instruction you had given, you would want it to be stopped, wouldn't you?
Once they are there, they're there. I
But
might
you would
have
want
wanted in the future the process to be stopped in the future, but once the notes are there, they're there. And if you refer back to my email exchange, I was very clear in terms of that notes had been retained, had been made and had been retained and were available.
So you would want typewritten notes not to be kept in the future, because that was contrary to the instruction that you had given, passing it on for Susan Crichton, is that right?
In principle, that may have been the case looking at the documentation.
That would be consistent with you telling Mr. Singh to scrap typed minutes, wouldn't it? i.e. what's written here.
I don't recall a conversation with Mr. Singh. I don't recall anything of that nature. I would not go around asking for things to be destroyed or deleted.
I'm not asking you at the moment about the destruction of anything. I'm asking you about the cessation, the stopping, the scrapping of the creation of typewritten notes.
That I can't recall.
Well, it would be consistent with the instruction that you had given, wouldn't it?
Yes.
Let's not keep typewritten notes
Yes.
to be circulated amongst a wide readership. Is that fair?
Yes.
Instead, notes should be kept by the security department alone?
I imagine other people would have written their own notes.
Was that permitted or forbidden according to the direction that you passed on from Susan Crichton?
No, it would be permitted.
So what was forbidden then?
I can only go by the email exchange with Susan Crichton, is to reduce the circulation of minutes.
And what explanation did she give for the need to reduce the circulation of minutes?
Reduce the risk of being widely circulated and then being subject to freedom of information or disclosure, as per my email.
Can we move to the next day, please, the 1st of August 2013, and look at poll 2013-9746. An email from Jarnell Singh at 9 o'clock in the morning to Martin Smith, copied to Roderick Williams. Who was Roderick Williams?
Post office lawyer.
Martin, I know Simon, I think that must mean Mr. Clark, is advising on disclosure. As discussed, can he look into the common myth that emails, written communications, etc., meetings, if it's produced, then it's available for disclosure. If it's not, then technically it isn't. Possible, which may mean possibly, true of civil cases, not criminal cases. Thanks, Jarnell Singh. And so would you understand this to be Mr. Singh asking Cartwright King, and in particular Mr. Clark, to advise on what's described as a common myth, that information not reduced to writing need not be disclosed?
Yes.
Was that a myth that you had heard percolating within the security department of the post office?
I can't be explicit, but I seem to recall there was some element of that within the wider post office.
And what do you mean by the wider post office?
Just within the post office itself.
Or a clerk in Cleethorpes, or a branch manager in Bodmin, or what within the
I'd say the
wider post
broader
office?
corporate level community.
Who, please?
I can't recall.
How widespread was this myth?
I can't recall.
Was it a myth that you actively encouraged and fostered?
No.
Was it a myth that you disabused people of?
No.
You let it persist?
By the email exchange with Susan Crichton, I ensured that there were minutes made. We were briefing solicitors in that meeting so that they were fully informed of what's going on, and then they could then decide what they wanted to disclose or use.
In your witness statement of yesterday, you pick up on the language used in this email here and draw a comparison to what Andrew Parsons said in the first meeting on the 19th of July.
Yes.
And what's the point that you're making?
That's the communication that was coming from lawyers.
And what's the point that you're making?
In terms of lawyers were saying that if it's written down, it's disclosable. If it's not, then technically it's not. And that's from an external lawyer as well.
And what's the significance of that in your mind?
Just relaying around this myth element of where it may have come from or what was going on in the post office.
So I understand it correctly. You're saying it is maybe an explanation for the request for advice, that the common myth might be a reference, given the similarity in language used, to what Andrew Parsons from Bond Dickinson had said in that first meeting.
Reading into that, yes.
Thank you. But in any event, aside from what Andrew Parsons from Bond Dickinson said about if it's not written but down, then technically it's not disclosable, you're telling us that it was also a myth that was circulating within the post office more generally at this time?
Yes.
Can we move to the next day, please, the 2nd of August 2013, poll 406799. This is the second advice, the so-called shredding advice of the 2nd of August 2013 that we looked at earlier to hear about the inspiration for the weekly hub meetings. And do you remember we looked at paragraphs 1, 2, 3 and 4. If we look again at 3, please, at the foot of the page. I asked you about the first sentence and whether it was accurate, and you said yes. The second sentence, participants were informed they should bring all Horizon-related issues they'd encountered to the meeting. Minutes were to be taken, centrally retained, and disseminated to those who required the information. This list to include the Post Office's Horizon expert witness. That appears to be the suggestion that Mr. Clark made. That wasn't translated into practice, was it?
No.
And was that because of the intervention of Susan Crichton?
Going by my email, that appears to be the case.
In that there weren't to be centrally retained minutes, and such minutes were not to be disseminated.
Minutes were to be taken. That was very clear in my email exchange, and they were taken, they were retained, and were available. But yes, in terms of the dissemination.
Can we move down to paragraph 4? 3 such conference calls were convened, each conducted on a Wednesday. A representative of Cartwright Kings attended each meeting. A minute taker was appointed for each call, and I understand that the minute takers retain their own handwritten minutes. Is that accurate, to your knowledge? Or was that accurate by the 2nd of August?
I can't recall because I wasn't there. I presume Rob King or Dave Posnett, who were attending, were making the minutes.
Do you know what happened to any of those handwritten minutes?
Well, they were all retained because the minutes were ultimately circulated from my email exchange with Susan Crichton.
Was that typed up versions of the Posnett King handwritten notes?
I don't know.
Moving on to paragraph 5, at some point following the conclusion of the 3rd conference call, which I understand to have taken place on the morning of Wednesday, the 31st of July, it became unclear as to whether and to what extent material was either being retained centrally or disseminated. The following information has been relayed to me. 1, the minutes of a previous conference call had been typed and emailed to a number of persons. An instruction was then given that those emails and minutes should be and have been destroyed. The word shredded was conveyed to me. Did you give that instruction that the electronic records and emails of a previous conference call should be destroyed?
I have no recall from that period from 10 years ago, but that is not me. That's just not me, what I would say or ask.
Have you any knowledge of such an instruction being given?
No.
Who would be in a position to give such an instruction, would have the power, the responsibility, the function to give such an instruction?
A number of people, I'd guess.
Who's within that number?
Obviously, my line manager, me.
So just if you can name them, Susan Crichton.
Susan Crichton.
You.
Me. And then Rob King as chair of that. And probably, I don't know, other people.
Who else?
It's hard to say. I wouldn't expect lawyers to be saying that.
I'm talking at the moment the people involved in this enterprise. Who
Yes.
amongst them would have the power to give an instruction like that?
I guess those three.
Those 3, okay. 2, Mr. Clark says, quote, handwritten minutes were not to be typed and should be forwarded to Post Office Head of Security. On that issue, did you give that instruction?
I don't recall.
That's more similar to what you have said you had passed on originally to Mr. King.
I don't recall whether I've actually asked for that or he's decided to say that.
Did you want to be the custodian of any minutes?
It'd be very unlikely that I would want to,
Why would it be unlikely?
because that's not what I see my role as. If he's chair, then he would have retained the minutes, the notes.
Are you aware of any such instruction being given that the handwritten minutes that the security department were writing up were not to be typed, but instead should be forwarded to you?
I don't recall.
Number 3, advice had been given to the Post Office, which I report as relayed to me verbatim, quote, if it's not minuted, it's not in the public domain and therefore not disclosable. If it's produced, it's available for disclosure. If not minuted, then technically it's not. And that second one is a facsimile of what Mr. Singh asked in his email to Mr. Smith, isn't it?
Yes.
To 4, please. Roman 4. Some at Post Office do not wish to minute the weekly conference calls. Do you know who at Post Office may not have wanted to minute the weekly conference calls at all?
I can only go by my email exchange with Susan Crichton, and that's the brief.
What does that mean?
She didn't want minutes being circulated to reduce the risk.
This is a different issue again. This is not minuting the calls at all. Were you aware of any such instruction being given?
No, because in my email exchange, I made it very clear that minutes were taken, or notes were taken and retained and were available.
Were you shown a copy of this advice at the time?
No, I don't recall seeing either of the clerk advices at the time.
Were you told the gist of it?
No, I remember having a conversation with Susan Crichton, and she raised a couple of areas about getting the central log more organised, and secondly, for the security team to have disclosure training.
What was the central log that needed to be more organised?
Of the issues that have been escalated.
And in what respect did it need more organisation?
I think all the issues looking at the documentation that they were in the minutes rather than actually having say for example, a central single Excel spreadsheet which they can be looked at, maintained and tracked.
But nothing was passed on to you of the nature of the 4 things that we've seen that Mr. Clark had been told?
No, I don't recall having that conversation.
Also on this date, the 2nd of August, can we look please at poll 0013 9747? And can we start, please, by looking at the second page? An email from Mr. Clark. Chaps, please consider first draft. I'd not object to any suggested alteration, including typos. And we can see from the foot of page 1 that the subject is advice first draft, sent, I think, to a series of lawyers within Cartwright King. And then further up the page, we can see an email from Steve Gelsthorpe to the same distribution list. Dear all, I attach a note which I believe captures all we talked about this morning. Please check. You chaps are closer to this than RH, I think that's Rupert Hawke, and I. And if there's anything I've not grasped or covered, you must let me know. Equally, if there's anything plainly wrong, you must let me know. I've seen Simon Clarke's note. The comment I have is how we're going to impart the advice to the post office that if there are factions within it who are running around trying to lay off blame for their own shortcomings by lying about the advice they've received, then they lose privilege. I thought Simon Clarke's advice would cover this. On reflection, it may be something for Andy, I think that's Andy Cash, to raise with Hugh and to note or to confirm in a letter to him. Do you know who the faction within the post office Mr. Gelsthorpe is referring to there, i.e. a faction running around trying to lay off blame for their own shortcomings by lying about the advice they've received, is referring to?
No.
Can you assist us with any help as to who he may be referring to?
No.
Is he referring to you?
I can't comment on what he's referring to, but I don't consider it to be me.
Were you aware at this time of people within your department who were beginning to realise that there were problems with the integrity of Horizon that ought to have been disclosed to the criminal courts, and that they were seeking to lay blame about lying about the advice they've received from lawyers?
No.
Were you aware of anyone in relation to the exercise that was being undertaken, the setting up of the hub and the bringing of issues to the hub and the recording of information by the hub, lying about the advice they'd received from Cartwright King?
Sorry, what's the exact question there, please?
Were you aware of anyone involved in the hub exercise lying or seeking to lie about the advice they had received about the retention of material and the disclosure of material?
No.
Have you any clue why these lawyers might think that their clients may subsequently seek to lie about the advice that they'd received?
No.
On your evidence, there's no grounds for these lawyers to think that at all, is there?
Correct. We're taking notes. Lawyers are on the call.
Can we turn to the 13th of August, please? Poll 2013 9690. And this is the email exchange that you've referred to a number of times so far, correct?
Correct.
Can we start, please, at the foot of the page? And it's the exchange, as I've said, of 13th and 14th of August 2013. It's an email to you from Susan Crichton at 8:34 on the 13th of August with the subject heading of Wednesday Call. That's a reference to the Horizon Hub calls that we've been talking about, which for the most part happened on a Wednesday, correct?
Correct.
She says to you, John, as part of our remedial action, I had asked you to set up and chair this call. I've had very worrying feedback, re this call, from Cartwright King, and it sounds like this is not being chaired. The participants are unclear as to its purpose, and no minutes are being kept. Or is there confusion? Can we discuss? Do you know what the very worrying feedback was?
No, I don't recall.
Can we look up and see your reply, please? Just if we can check the date, the 14th of August 2013 at 7:39 in the morning. You say, Susan, we'll just deal with this paragraph by paragraph if we may. The brief given by yourself for this meeting was to provide in effect an under-the-radar escalation point from across the business of issues that may impact the integrity of the Horizon system. You were frustrated in regards to the production and circulation of the Helen Rose report and therefore did not want any electronic communication which may be subject to FOI, freedom of information, or disclosure. Is it right that essentially in this first paragraph, Susan Crichton made, you're referring to 3 points that Susan Crichton made to you. Firstly, the meeting should be under the radar, yes?
I have written that, yes.
Well, did that faithfully reflect what she told you?
I can only read what I'm reading here now, so if that's what I've said, then yes.
Secondly, that she told you she was frustrated by the production of the Helen Rose report, yes?
Yes.
And thirdly, she told you that electronic communication should not be created because they might fall to be disclosed in one way or another.
Yes, I think it was probably, if you look at my interpretation of the next email, is reducing it to legal privilege, which is the second paragraph, as much as possible.
Can I examine each of those three in turn, please? Firstly, you say the brief given by yourself, i.e. you, Susan, for the meeting was to provide an, in effect, under-the-radar escalation point. This was to be a hub concerning issues about the integrity of Horizon, correct?
Correct.
Under the radar, would you agree, means things which should go undetected, which should leave no trace, which cannot be seen, correct?
I wouldn't necessarily agree with that. Looking at another paragraph in there, it was the meetings were conducted with lawyers, therefore everything was being reported to lawyers and escalated to lawyers. But taking the interpretation of this, she didn't want it widely circulated, which would then avoid legal privilege where that could be applied.
You're saying this is all about privilege now. It's nothing to do with the creation of documents in the first place. Is that what you're telling us?
Looking at one of my paragraphs, I believe it was reducing the risk and keeping it within legal privilege wherever it could be.
The words you used are an under-the-radar escalation point. Just as a matter of language, would you agree that under the radar means something which cannot be detected, something which leaves no trace? It doesn't show up. It cannot be seen.
As language, yes.
Why was it important that discussion of issues which may impact the integrity of the Horizon system should not be detectable, that no trace of them should be left, that they should be conducted in a way that meant that they couldn't subsequently be seen?
See, I don't agree with that because it's been reported to solicitors on the meeting, and I think it's more about reducing the risk of disclosure by using legal privilege.
So that's a convenient moment before we move to the rest of the email. I wonder whether we can take a break until 22.
Yes, of course. Thank you very much.
Thank you, sir. So good morning. Can you see and hear me?
Yes, I can. Thank you.
Thank you very much. Mr. Scott, can we continue to look at poll 2013-9690? we were looking at the first paragraph. I'd asked you about the under the radar comment. You continue, that's you, Susan Crichton, were frustrated in regards to the production and circulation of the Helen Rose report. Why was Susan Crichton frustrated that the Helen Rose report had been produced?
I cannot recall.
Was it because it revealed a problem with the integrity that data produced by Horizon?
I cannot recall.
Why was she frustrated that the Helen Rose report had been circulated?
I cannot recall. I can only go by this email.
Was it because there was a report that was critical of the integrity of Horizon, now available for disclosure?
I don't know.
And that reports should not be written, less still circulated, that revealed problems with the integrity of the data produced by Horizon?
Don't know what she's thinking.
Wouldn't you challenge her and say, hold on, if there's a report that's critical of the integrity of the data that Horizon is producing, we prosecute people using that data and they get sent to prison. It's good that such reports are produced, and it's be really good if they're disclosed. Isn't that what a head of security, a former police officer, would say to somebody who was saying, don't write reports and don't circulate them?
I guess that's a good opinion.
Did you say that?
I can't recollect. I don't know whether I challenged or not.
Your email continues that, therefore, she did not want any electronic communication which may be subject to freedom of information or disclosure. Disclosure, capital D there, means disclosure to a court, yes?
I can only go by that, and I presume the interpretation, yes.
How did you come to believe that the Post Office's General Counsel, Susan Crichton, did not want any electronic communications created which may be the subject of disclosure to a court?
Sorry, what was the first part of the question?
How did you come to believe that Susan Crichton did not want any electronic communications created which may be the subject of disclosure to a court?
Must have been a conversation with her.
So the General Counsel was saying, in this enterprise concerning the integrity of Horizon, I don't want electronic communications created which may be the subject of disclosure to a court. Correct?
I can only go by this email.
And so the answer would be yes then, because
Yes.
that's what the email says in terms.
Yes.
Again, would you have challenged her?
I may have, I may not. I can't recollect.
Why may you not have challenged her? So-
Because I just cannot recall. I'd like to think I challenged her.
Was the reality that you wouldn't challenge her because you were part of an enterprise too that didn't want the creation of electronic communications which may be the subject of disclosure to a court?
No. I ensured that there were notes taken,
Handwritten notes?
handwritten notes or whatever notes.
No, handwritten notes. That's what you ensured, isn't it?
Yes,
Why did you want handwritten notes to be created?
to ensure that all the information was captured.
Why not electronic notes?
Because that's the brief I had from Susan Crichton.
It's because they're not easily discoverable, isn't it?
I don't know on that
They
one.
leave no trace, don't they? They can be hidden away in a cupboard, can't they?
I can only take my brief from Susan.
An electronic note leaves a footprint, doesn't it?
Yes,
And the fact that it existed but has been deleted leaves a footprint, doesn't it?
Yes,
That's why you don't want electronic notes created, isn't it?
but notes were created. Notes were maintained.
I'm asking you about why you wanted handwritten notes, not electronic notes.
Because that's the brief I had from Susan Crichton.
It's because they are less likely to be found and disclosed, isn't it? Mr. Scott?
Mm-hmm.
It's because they are less likely to be found and disclosed, isn't it?
In terms of that, I can only assume from my second paragraph that she wanted to reduce the risk of FII disclosure with the legal privilege not wrapped around it.
Let's turn to the second paragraph. The conference calls have been set up and they're chaired by a senior manager from the security team. And then I'm briefed thereafter. I wasn't aware I had to specifically chair, but that's easily remedied. At the outset, the purpose of the call was given that this was an informal escalation point and no electronic notes would be taken or circulated, and communication would be created, which looks like an incomplete part of a sentence. Written notes written notes have been taken for each call and activity has been driven behind the scenes. Just stopping there. Why would electronic notes not be taken?
Because that's the brief.
Is it because the taking of an electronic note would create a potentially disclosable record of the call?
Potentially, yes.
Was it so that disclosure obligations in criminal proceedings could be avoided? If you don't create an electronic record of a discussion, you don't have to disclose it.
No, because the meetings were involving lawyers, both internal and external. They were being briefed on all the issues being escalated and notes were being taken.
An electronic record has the distinct disadvantage, doesn't it? Would you agree? For a person who wishes to subvert their disclosure obligations, that an electronic record can be looked for and more easily found by others.
Correct, it's more easily...
Sorry?
Correct, it's more identifiable.
It's difficult to remove all traces of an electronic record, isn't it?
Yes,
It leaves a footprint, even if it's deleted, doesn't it?
yes,
Whereas a written note can be hidden, concealed, or even destroyed, can't it?
in principle.
You say here, written notes have been taken for each call and activity has been driven by the scenes. Was that done on the instructions of Post Office's General Counsel, Susan Crichton?
Going by this email, I'd say yes.
Did she instruct you that only written notes should be kept?
Going by this email, I'd say yes.
It says, just in the line above the ones highlighted, at the outset, the purpose of the call was given that, and then following. Did you give Mr. King the instruction that's referred to there?
Sorry, say that one again, please.
Yeah, the line which says at the outset, i.e. at the outset of the conference calls, the purpose of the call was given that this was an informal escalation point and no electronic notes would be taken or circulated. Did you give that instruction to Mr. King?
Going by this email, I suspect I did pass that brief on to Rob King.
Did anyone that you spoke to ever push back and say, hold on, why aren't we allowed to keep an electronic record?
I have no recollection.
Did anyone say, hold on, why aren't we allowed to communicate about these matters using electronic means?
No recollection.
Was there a common understanding, a meeting of minds amongst those in the security department and those on the call, that the reasons for not creating disclosable records about Horizon integrity issues was that that would avoid having to disclose documents about Horizon integrity issues in the future?
I have no recollection, but that wasn't the culture within the team.
It wasn't the culture.
No. Notes were made. Solicitors were briefed.
you continue, for an example, a potential Horizon glitch was raised that had been reported previously to Simon Baker. This was then managed subsequently directly with Roderick Williams and Steve Beddoe by myself in a manner to bring it under legal privilege as far as possible. So you managed an issue to bring it under legal privilege as far as possible. What did you do to bring this issue under legal privilege as far as possible?
I can only go by that email, as in I must have brought Steve Beddoe into contact with Roderick Williams, who would have then dealt from there on in.
So you involved a lawyer, is that right? Is that what you're saying?
And he would determine what's legal privilege or not.
Why did you want to manage the issue under the cloak of legal privilege?
Because that's the direction in terms of the legal services wanted to take. They wanted to have access and sight and decide whether they wanted legal privilege is applicable or not. Going by that email.
You were aware of Horizon system issues that would require management by both the Post Office and Fujitsu at this time?
Yes.
Including Horizon system issues that could lead to discrepancies or shortfalls or losses being shown?
I was aware there's issues being raised.
Why would those require to be managed, quote, in a manner to bring them under legal privilege as far as possible?
I can't recollect.
Whose idea was it to manage Horizon system integrity issues in a way to bring them under legal privilege as far as possible?
I can't recollect.
Was it a decision of Post Office or Fujitsu or both?
I have no idea on that.
If it was within the Post Office, who was responsible for determining that Horizon integrity issues should be managed so far as possible under legal privilege?
I have no idea.
Who are the possible candidates for it?
Clearly, my line manager, Susan Crichton. There may be others.
Can we move on, please, to paragraph 5? Which is the last paragraph, the one beginning clearly. Clearly, I will now attend the conference calls as chair and following on from the previous discussions and the steer below, unless otherwise directed. This will become a formal meeting with terms of reference, electronic notes, actions and appropriate governance within such approach. This will be built into the operating and governance model, and the previous notes and actions over the last 3 will now be electronically recorded and circulated. This does run the risk that more communication will be generated electronically with issues, reports and actions responded to, etc., that may include inappropriate comments, opinions, assumption that may be subject to freedom of information and disclosure, as in the Helen Rose report. To your recollection, was there a reply to this from Susan Crichton?
I don't recall. I don't even recall this email until it was sent to me.
To the best of your recollection, did she say, hold on, we've got disclosure obligations. That's not a reason not to create documents.
I have no recollection.
Why were you raising the risk of the generation of information electronically that may be the subject to disclosure in a court?
Sorry, can you...
Yes, in that last paragraph, why
Yes.
were you running the risk? Say, look, if I do what you're now telling me to do, which is have a more formal meeting with some terms of reference, creating electronic notes, operating under a governance model, you should know that that's going to create documents that might be disclosed. Why were you telling her that?
Because it appears from the earlier paragraphs that she didn't want documents widely circulated, then that would come and avoid legal privilege.
And so were you saying, be careful what you wish for, Susan?
I can only go by this email.
Is that what you're essentially saying?
I'm not too sure what I was saying in terms of...
Well, help us.
I'm just advising her then that where she was challenging around circulation of the Helen Rose report, then obviously that's similar. It may be available for more disclosure or freedom of information.
In any event, does this exchange indicate that there hadn't been a similar formal route or mechanism for regular liaison between legal and security on Horizon integrity issues until after the first Simon Clarke advice was written?
I can't recollect.
Well, he was suggesting it be introduced, if you remember.
Mm-hmm.
Does that tell us that it didn't exist beforehand?
That may be the case, but obviously I wouldn't have known if the security operations team for fraud were having conversations already with Cartwright King, so I wouldn't have known what their activity was.
Can we turn to the next day, please? That document can come down and look at poll 0013 9749. This is an attendance note of Martin Smith of Cartwright King of the 14th of August 2013. And under the detail, it records MJS to SC, who at the moment I'm going to take to mean Susan Crichton.
Mm-hmm.
John S. will not be on conference call. He admitted in an email to her last night to sending out instructions to shred. Did you send such an email to Susan Crichton?
No, I would not do that.
Did you say anything to that effect to Susan Crichton?
I can't recall if I've had a conversation with her, but that's not a thing, I would say.
Do you know where Susan Crichton may have got such an idea from?
No.
Can we turn to poll 0013 9748? This is later that day, the 14th of August. Again, an attendance note by Mr. Smith. And look at the detail. Telephone call from JS. Again, I'm going to assume that that's John L. Singh because of the description of you as John Scott rather than JS. Telephone call from John L. Singh. John Scott will be in the conference call. Martin Smith said not appropriate. Had you done anything, to your understanding, that was wrong, that meant it would be inappropriate for you to be included in the next conference call?
No.
On your account, you'd just been following orders.
Yes.
And yet it seems that it was not appropriate for you, according to Mr. Smith, for you to be on the call.
That's what he stated.
Had you done anything that might make it inappropriate for you to join the conference call?
No.
In fact, I think the record shows that you did attend the conference call on the 14th.
Yes.
Can we divert for a moment from this period of July and August 2013 and look back at an earlier episode to see whether it assists us? It's poll 0010 7696. wonder if we can just start at the bottom of page 2, please. Thank you. Can we see a message from Emily Springford? Do you remember who she was?
No.
To a collection of people, including Angela van den Boogaard, Hugh Flemington, Susan Crichton, and you. Their heading is JFSA claims, disclosure, and evidence gathering. And the email is titled Privileged and Confidential. Dear all, and then over the page. As you're aware, the Post Office has received 4 letters of claim from former sub-postmasters, making a number of allegations about the training they received, the support available to them in using the Horizon system, and the Horizon system itself. There's a possibility that these claims will be followed up with court proceedings, in which case the Post Office will have a duty to disclose to the claimants all documents relevant to the claims, even if they might adversely affect the Post Office's defence. You agree with everything so far that's said?
Yes.
This obligation extends to soft copy documents, emails, and all documents stored on the IT network, hard drives, handheld devices, and so on, as well as hard copy documents and manuscript notes. Please ensure that this communication reaches everyone in your department who has access to or is in a position to create documents relating to the issues arising in the claims, as more fully set out below. I've started a list of teams which we believe may hold relevant documents. The list is attached. I'd be grateful if you let me know of any other teams which might hold documents relevant to the claims. So this is saying we've got 4 letters of claim in from JFSA claims, and there are some disclosure obligations that arise accordingly. Agreed?
Yes.
And if we scroll down, document preservation. The Post Office must take immediate steps to preserve all documents which might potentially be relevant to these claims. Relevant documents are those which contain information about the issues below. The sub-postmasters or branches in question, the recruitment of sub-postmasters, the training given to sub-postmasters, the support given to sub-postmasters in using the Horizon system, the integrity of the Horizon system, and the Post Office's branch accounting procedures. Please note that no historic time limit applies, so that all documentation within these categories should be preserved regardless of when it's created. Could you please inform the members of your team who hold or create documents in these categories that they shouldn't delete or destroy any documents in these categories until further notice? It's important you keep a note of any routine document destruction policies that you suspend within your department and the dates on which they're suspended, together with a note of any steps that you take to ensure that your department complies with the above requirements. And then do you agree with everything so far?
Yes.
As an understanding correctly of disclosure obligations?
Yes.
Under document creation then, it's very important that we control the creation of documents which relate to any of the above issues and which might be potentially damaging to the Post Office's defence of the claims, as these may have to be disclosed if these claims proceed to litigation. Your staff should therefore think very carefully before committing to writing anything relating to the above issues, which is critical of our own processes or systems, including emails, reports, or briefing notes. We appreciate that this will not always be practical, however. Where it's necessary to create a document, creating critical comment on these issues, it will in certain circumstances be possible to claim privilege over the document so that the Post Office will not have to disclose it in any proceedings. As litigation is now a distinct possibility, the document will be privileged if its dominant purpose is to give or receive legal advice about the litigation or to gather evidence for use in the litigation. This also applies to communications with third parties, i.e. other organisations, provided they're confidential and their dominant purpose is as set out above. All of the following steps should be taken in order to maximise the chances of privilege attaching to a document. If the dominant purpose of the communication is not to obtain legal advice, try to structure the document in such a way that its dominant purpose can be said to be evidence gathering for use in litigation. Mark every such communication legally privileged and confidential. If you're sending the document to someone, state in the covering email, etc., that you're not waiving privilege by doing so. Request that the recipient of a communication confirm the document will be kept confidential and he or she will not forward it to anyone else. Think very carefully before replying all on an email. Where possible and appropriate, copy a member of legal services into the communication and make sure that, over the page, you're doing so to enable them to advise on the content. Please note that copying a member of legal services into the communication alone will not necessarily suffice. Now, we may, in due course, investigate the propriety of some of the advice given there with other witnesses and how it was subsequently acted upon. But how did you understand the advice that you were given here?
Is there a particular part or the whole lot?
The whole lot.
It was giving advice on disclosure.
Was it saying to you, be careful about the creation of documents that might be damaging or potentially damaging to our defence of the claim, and do everything you can to badge them up as privileged?
In part, looking at that, yes.
Did that form part of your considerations when, in August 2013, you had to make decisions as to the approach to be taken with the Horizon Hub meetings on Wednesdays?
So I don't recollect this email at all, and whether it had a part on that decision 2013 or not, I have no idea.
It says it's important that we control the creation of documents. Your staff should think very carefully about committing anything to writing, in particular if they're critical of the Horizon system or the reliability of its data. Isn't that what you were instructing should occur in the July and August Horizon Hub calls?
In terms of the hub calls, it was about informing the solicitors in terms of all the issues and for them to decide whether legal privilege would then apply.
Sorry, say that again. In terms of the hub calls, it was about informing the solicitors for them to decide whether legal privilege should apply.
So obviously the issues were being picked up and dealt with and progressed, but of course you had lawyers on the call to make an assessment whether something was disclosable or not.
What's that got to do with only writing things on pieces of paper and not recording them electronically?
Because once it goes much more broader, then to a broader audience, then it's outside of the legal framework. The lawyers can't make an assessment, or can make an assessment, but it's broader.
Can we go back to Mr. Clark's so-called shredding advice at poll 406799? And can we turn to page 5, please? And look at paragraph 9. He advises the Post Office, quote, "The duty to record and retain material cannot be abrogated. To do so would amount to a breach of the law, and in the cases of solicitors and counsel, serious breaches of their respective codes of conduct. Accordingly, no solicitor, no firm of solicitors, and no barrister may be a party to a breach of the duty to record and retain. Neither may they act in circumstances where they're aware or become aware that a practice has developed within the investigative or prosecutorial function that such that the duty to record and retain is being deliberately flouted or avoided. Again, to do so would amount to breaches of both the law and codes of practice. And then this, a decision-based failure to record and retain material would readily amount to such a practice. Such a decision, where it's taken partly or wholly in order to avoid future disclosure obligations, may well amount to a conspiracy to pervert the course of justice on the part of those taking both taking a decision and those who implement such a decision, where they do so in the knowledge that it was taken partly or wholly for that purpose. Was the purpose of the instruction that you gave a decision to not record and retain material in order to avoid disclosure obligations?
No, we were recording. We were taking
Sorry?
notes. We were taking notes.
On pieces of paper?
On pieces of paper, but they were there, they were retained, and on the August, they were still there and retained and able to be used and circulated.
Can we go, after that excursion, back to where we were in the chronology, to poll 308 3930. As I mentioned earlier, the conference call on the 14th of August shows that you're present. And despite what we'd read earlier about it being inappropriate for you to join the call, you and others are on it. Were you ever told that there was doubt about whether you were going to be permitted to take part in this call and future conference calls?
No, I don't recall that at all.
After your email exchange of the 13th and this day, the 14th, with Ms. Crichton, you just turned up on the phone?
No, I said in my email that I would now be attending and chairing.
Yes, but you didn't know that there had been in the background this discussion amongst lawyers about whether it would be appropriate for you to attend or not?
No.
You just joined the call. Can we move forward to the 19th of August, please? Poll 0013 9691. This is a later email trail involving Rob King, Jarnell Singh, and then earlier Dave Posnet and Andy Parsons. I don't think you're copied into it. Can we look at the second page, please? And then look at the foot of the first page, please. And then scroll up, please. We see an email from Mr. King of your department to Mr. Singh. Apologies if I seemed a little evasive earlier. To date, I've worked to the remit of establishing a group whereby issues and concerns are raised and recorded. See below. However, with an initial mandate of not circulating notes made, it's difficult to apply the usual governance on the process. Notes have been typed, actions captured, and will be circulated. This should provide the proper framework for resolving issues. I was under the impression that a working group would be set up to deal with these, placing the weekly conference call superfluous. Investigators have been instructed to report back any issues raised during interview. These will be fed through to legal and a record made of them, I still maintain that security is not the best place, though, to resolve issues with the Horizon system. As you know, John Scott is chairing this con call going forward. It may be useful for you to rely on reply to John, Susan's concerns, speak tomorrow. The line, however, with an initial mandate of not circulating notes made, does that reflect your understanding of the initial mandate? There was to be no records circulated for these meetings.
Yes, but notes were to be made.
He says that security is not the best place to resolve issues with the Horizon system. Do you know why that was?
Because I think any issues escalated may be much broader than security.
And so who, was this discussed with you?
I can't recall.
The last line, it may be useful if you reply to John, or if you relay to John Susan's concerns. Do you know what Susan Crichton's ongoing concerns were?
He sent a document which outlines I identify the issues and hunt down the issues and root cause and deal with them.
There are, that can come down, thank you. There are regular calls, Horizon issues, on the 21st of August. I'm just going to give the reference rather than looking at it. Poll 2013-9726, at which you're an attendee. And the 28th of August, poll 308-3935. And you are an attendee. In September 2013, Susan Crichton left the post office, correct?
I believe it's about that time.
And there wasn't an immediate replacement for her, was there? Somebody had to act up as an interim. Do you remember that?
No, I thought an interim person was employed, not an interim general counsel from external.
Why did Susan Crichton leave?
I have no idea.
She was somebody with whom you worked closely,
She was my line manager, yes.
and she was somebody who you worked closely with.
Yes.
Was there no discussion as to why she left?
No.
Did she leave suddenly?
I think she left the next day after informing me or others.
Was there no discussion about why she departed?
I would not discuss that with a line manager. That's personal to them.
Did she not say to you, I'm leaving because X, and there isn't somebody in place ready to take over from me? We've got to get an interim in.
I don't recall, no.
Was her departure anything to do with the issues that we've just been looking at this morning?
I have no idea at all.
Can we move forwards, please, to the... I'll leave the Susan Crichton thing. We've got no documents that help us at all as to why she said she was leaving one day and disappeared the next. Can we turn, please, to the 9th of October and look at poll 0013-9695. Can you see, just wait for that to be expanded so we can read it. An email of the 9th of October and I don't think you're on the copy list. Is that right?
I can't see my name.
It's an email from Gail Peacock from Branch Training and Support attaching something called the protocol. She says, apologies for the delay in circulating these notes from last week's notes. We had a mix-up about who was taking them, so I've put some together based on the bits I've captured. I've also attached a protocol document, which Martin talked about on the call last week. I think there are still a few tweaks to be made to this, but you can see the general principles. And so this is an email, would this be right, to a working group, but not including you, enclosing a protocol.
Can I see the names again, please?
Sorry?
Can I see the names again?
Yes. If we just scroll up, please. And a bit more. Thank you.
I don't recognise a couple of the names, but most of them are those who attend the meeting that I've seen in the minutes.
Can we look at the protocol itself, please? Which is poll 00139696. I want to try and do this quite briefly because it's a 7-page document. But what I'm going to suggest is when we read through it, we can see that it's a rather good, if not excellent protocol about how the Wednesday morning telephone conferences should be conducted, about how to identify material, to record material, to retain material, which may be the subject of duties of disclosure. It starts off with a citation, can you see under the preamble, from something which is in fact from the forward to the Attorney General's guidelines on disclosure, that disclosure is one of the most important issues in the criminal justice system. And it reads, as a prosecutor, the Post Office Limited is under a positive duty to identify, record and retain any information which might assist the defendant in preparing or presenting his case or which might undermine the prosecution case against him. We must be able to prove that where we rely on information provided by Horizon Online to prosecute, that system's reliable and accurate, that those using the system have been properly trained, and that appropriate support systems are in place and available to users. The duty extends to all information held by the prosecutor or to which he may have access, and to information which came into existence before any crime was detected, but which meets the test for disclosure. As a fair and public-spirited prosecutor and always acting in the interest of justice, Post Office will take all reasonable steps to ensure that we're in a position to fully meet our disclosure duties. Accordingly, we will in future collect and retain any and all information which might suggest that Horizon Online may not be working as it should, or that our training and backup systems are less than we would. I suspect there's nothing with which you disagree in those two paragraphs.
Correct.
Those best placed to provide the information we are required to identify, record and retain are those within the organisation who are Horizon Online users, or those who on a regular basis come into contact with Horizon Online and its users. It's those persons, department and sections, therefore, at whom this protocol is directed and who will be our front line in the information gathering exercise. Defendants are entitled to this information where it meets the test for disclosure. We would not wish to be associated with any wrongful conviction. Over the page. Wednesday morning telephone conferences. Post Office will conduct a telephone conference each and every Wednesday morning. The primary purpose, will be to identify, record, retain and disseminate all such materials set out in a clause below. 2, Post Office will appoint a chair. The chair will not be a head of department or section mentioned in clause 3.2 below, or a representative thereof, but may be a member of staff of such a department. Chair won't be a person mentioned in a clause below. The functions of the chair are set out in a clause below. 3, attendance. The chair will ensure the attendance at conferences of those heads of department or section set out in a clause below. or such departments or sections as are responsible for the functions indicated in that clause. 3.2, the following are the departments to which a clause above refers: criminal law, litigation, civil law, post office security, and others. 3.3, in addition, the chair will assure attendance at each and every conference of the following. Scroll down, please. Solicitor from Bond Dickinson, solicitor from Cartwright King, a minute taker appointed by Bond Dickinson. They will take all reasonable steps to ensure that the appointed representative and minute taker is the same individual at each and every conference. 4, functions and duty of the chair. I'm going to skip over those. If you go over the page, please. And go to 5, duties and responsibilities of persons attending Wednesday morning telephone conferences. You'll see the duties set out in 5.1 to 5.5. And then 6, a definition of equipment and materials subject to the protocol. And then 6.2, additional categories of material subject to the protocol. Any information in whatever form which relates to or is associated with any aspect of Horizon Online, ... which may indicate the presence of a defect, bug, fault, or virus, tend to suggest that any data produced may be inaccurate, false, or otherwise unreliable, tend to suggest that any balance produced may be inaccurate or otherwise unreliable, indicate a failure, error, or inadequacy or insufficiency in the presentation of data, indicate a requirement for further training, indicate an inadequacy or backup or support, indicate a requirement to alter, modify, rearrange, or redefine any process, etc. Would you agree that this protocol appropriately captures the duties to create, identify, record, retain material which may be subject to duties of disclosure?
Yes.
Why was it not in place for a decade before?
I have no knowledge on that one.
You were head of security.
Yes.
Your department was responsible for investigating and instigating criminal proceedings against hundreds of sub-postmasters. Why was a protocol like this not in place before late 2013?
I did not know that these issues were not being captured. I would have expected the IT department to have been capturing these and feeding these through had they had concerns.
Do you agree that a protocol such as this should have been in place at all material times when sub-postmasters were being prosecuted?
Yes, I think that would have been best practice.
When you say best practice, you mean required practice by the law? That document can come down, please. In your witness statement of yesterday, you've analysed the contents of a series of documents that were created concerning the July and August 2013 weekly meetings, and you've made points about them, drawing extracts from them and analysing them over the course of 10 pages or so.
Yes, I've made observations.
And that's in relation to an allegation that's been made against you in the past, that you were responsible for an order that minutes should be shredded.
Yes.
When you were reviewing the sufficiency of evidence to prosecute sub-postmasters, did you subject that evidence to the same level of scrutiny?
In terms of prosecution decision,
Yes.
I would expect it to have done so, yes.
Because we can see from your witness statement that where the allegation is made against you, you analyse all of the material pull parts from here and there, put them together, and draw inferences from them, make denials, agree with certain things, yes? Is that what you did when you were reviewing files against sub-postmasters?
I'd have read all the file documents that were forwarded to me. I would have read the suspect offender report. I'd have probably read the tape summary, and most definitely the legal advice that would have been provided.
Did you read the underlying material?
Online material.
Underlying material, rather than somebody else's summary or views of it?
I may have looked at it on occasions. I'm not saying that I would look on every single occasion.
Or did you think because it had passed through legal and they had recommended prosecution, it was your job to rubber stamp it?
No, I would still be looking to just to know and understand.
Did you ever say a case should not be prosecuted?
Obviously, you sent me a document where it does say prosecution won't go forward.
In your 9 years as head of security,
Yes,
how many times did you say that a case should not be prosecuted?
I can't recall.
Can we turn to the offender report, which you just mentioned?
Mm-hmm.
And so moving away from the approach taken to disclosure to the creation of reports for the purposes of bringing criminal and disciplinary proceedings against sub-postmasters and clerks. Do you recall a document called Security Operations Case Compliance?
No, you've sent it to me in the bundle, but I don't recall that at all.
Can we look at it, please? Poll 00119717. Thank you. Can you see that this is a document headed up Security Operations Team Case Compliance? So the Security Operations Team came under your responsibility.
Yes.
This is in relation to a particular case. We've got lots and lots of these in the same or similar format. And can you see that in the left-hand column there is a reference to variously the case file, the offender report, the taped interview record, appendices A, B, and C, then scrolling down. The discipline report, and then stakeholder engagement. Yes?
Mm-hmm.
And there are 50 items against which compliance is seemingly judged. Can you see that?
Yes.
And then in the right-hand column, there is a mark, a compliance score as a percentage, which if the person submitting the file gets it all right, they get 100, so 100%. This person submitting this file got 94%. Can you see that? Do you remember this case compliance approach?
No, I have no recollection at all.
In which issues are identified and a weighting is given to each of them?
No, this would be a sort of a level of operational detail that I wouldn't have engagement with. This would be with the head of security operations.
How many people were you responsible for when you were head of security?
At the outset, I think it was about 110, and that dramatically reduced over the years.
To?
I think, well, less than 50, I think.
And so you in your 9 years wouldn't be responsible that there was a process being undertaken to measure case compliance with a series of standards?
I'd expect it to be there, but I wouldn't be getting involved in it. That would be the head of security operations or head of fraud in the earlier days.
But wouldn't you receive reports to say, we're doing well, we're not doing very well on case compliance?
I don't recall receiving reports. That's not to say I didn't get a overall measure.
Were you aware of a suite of documents that was circulated very frequently within your department, informing their staffs that they were to be the subject of case compliance checks?
I've seen it in the bundle, but I don't recollect seeing that before.
So this was going on, as you now recall it, without you knowing?
As far as I'm aware, yes.
Can we look at another one of the suite of documents, please, that was distributed along with these case compliance score sheets? Poll 0011 8101. And can you see the heading of this document? Post Office Limited Security Operations Team, so the same team, compliance, guide to the preparation and layout of investigation red label case files, and then a subheading, offender reports and discipline reports. Can you see that it's at the bottom of the page, said to be in confidence? And that's at the bottom of each page. And if we go over the page to page 2, please. And if we just read through the purpose of the document. The purpose of the suspect offender report is to provide a storyboard of events and evidence of an investigation to the relevant stakeholders and criminal law team to enable a decision to be made as to the future conduct of a case. And so these are the reports that you got. Yes?
Yes.
This guide is produced for all security operations managers, irrespective of location. 3, the general principle is that the description of investigation activities should read in the sequence they occurred, so that it may be necessary to reorder paragraphs or elements within them. The following is only a guide. And then if we look at the foot of the page, please. Can you see, so I've missed a part out that I should have gone to. It's the 5th paragraph, the one beginning the text. The text element of the suspect offender report should commence immediately underneath the preamble. The header or footer on the report should read Post Office Limited, Confidential, Investigation, Legal. And we'll come back to that in a moment. And then if we scroll down, please, we'll see the contents starting to be listed of an offender report, a preamble which should have a header and footer, and the investigation background, the offender interview details, what happened post-interview, and scroll down, please. And then the contents of a discipline report under paragraph 2, headers and footers, background, offender interview details, and then over the page, post-interview. And then we scroll down, hold on, if we go back, please. Back up a page. Thank you. The offender report, more detailed guidance is given. Preamble, headers and footers, it repeats the point that Post Office Limited, confidential investigation, legal should be printed. Does that reflect the fact that legal professional privilege was claimed over the offender reports?
I believe it was.
Can we go to, I'm not going to read it all, can we go to page 9, please? and we're still in the part of the document that's dealing with the offender report rather than the discipline report. 1.24, details of failures in security, supervision, procedures and product integrity. This must be a comprehensive list of all identified failures in security, supervision, procedures and product integrity. It must be highlighted in bold in the report. Where the investigator concludes there are no failures in security, supervision, procedures and product integrity, a statement should be made and highlighted in bold. Would you agree that that statement of the things to be included in the offender report, insofar as it refers to product integrity, would include anything that emerged in the investigation, whatever its source, about issues with the accuracy or reliability of Horizon data?
I'd expect so, yes.
And it would include issues about the integrity of the Horizon system and the data that it produced?
Yes.
And would that be because those are things that are all capable of undermining a prosecution case?
Assume so, yes.
And they are relevant issues for a person deciding whether there is a realistic prospect of a conviction to consider?
Yes.
Such people positively need to have such material identified to them, don't they?
Yes.
It will also assist, would you agree, in the discharge of disclosure obligations, to have the material collected together and highlighted in bold in one place?
Yes.
Can we scroll on, please? We just stop there. Just scroll up just a little bit, please. A bit more. We then, in paragraph 2, turn to the discipline report. And we see that the header and footer of this is, by contrast, only to be Post Office Limited Confidential Investigation Personnel. Yes?
Yes.
And then can we again scroll through to page 10 until we get to paragraph 2.15? Thank you. It reads, details of failures in security, supervision, procedures and in product integrity. This must be a comprehensive list of all failures in security, supervision, procedures and product integrity. It must be highlighted in bold in the report. Where the investigator concludes there are no failures, a statement to this effect should be made and highlighted in bold. So the same as in relation to the offender report. Agreed?
Yes.
Again, it continues, however, significant failures that may affect the successful likelihood of any criminal action and or cause significant damage to the business must be confined solely to the confidential offender report. Care must be exercised when including failures within the discipline report, as obviously this is disclosed to the suspect and may have ramifications on both the criminal elements of the inquiry as well as being potentially damaging to the reputation or security of the business. If you're in any doubt, discuss with your team leader. Would you agree that this is in Post Office written policy, a command to include only in a document that enjoys privilege any issues that may affect the successful likelihood of criminal proceedings?
That's how it reads.
It therefore included an explicit instruction to keep secret and not to disclose any Horizon integrity issues, didn't it?
No, because that'd be reported to the lawyers who would then consider the requirement for disclosure out to the suspect offender or his or her lawyers.
But not disclosing in a report that a suspect would see any issues that may affect the success of criminal proceedings. The reason given for that is that it was potentially damaging to the reputation of the business, isn't it?
The report that was given to the suspect offender would have been a discipline report around their employment or around their contract, not about any criminal investigation. That would be reported to the lawyers, who would then make a decision of what they disclose to that individual.
And so this is saying, be careful not to let things leak out that might cause damage to the business.
In part, yes.
Was that the prevailing attitude of mind whilst you were head of security?
I'd say no. Bear in mind that we were communicating out as part of the prevention strategy of saying what some of the security weaknesses were, so that we could actually then let them know that we were monitoring it and we will be putting prevention in.
This document and documents in the same terms or similar terms were distributed, according to emails that the inquiry has received, to very many security staff under your command during your tenure in your 9 years. And they were told that not only must they do that which is included in these paragraphs, but they would be audited to ensure compliance, to make sure that they didn't breach the restrictions included here. Did you know that was going on?
No.
But it happened on your watch. How did that happen?
I just have to give my apologies that I did not see that, or the senior management of the security operations team didn't spot it.
Can we turn, please, to poll 0011 8152? This is another one of the suite of documents that was regularly distributed to your staff. In the pro forma for the discipline report and the offender report, there was a section which required the maker of the report to include an identification code. And this document was part of the suite of documents distributed to them, telling them which identification code to use. Do you see anything wrong with this document?
Very much so. It's very racially offensive.
Which parts?
I'd say it's all.
Sorry?
All.
This was distributed regularly to your staff on your watch, telling the staff that they needed to use these codes and they would be audited for compliance if they didn't. How did that come about?
I have no recollection. I do not recall this document. Had I seen it, I would have challenged and had it resolved.
Did any of your 100 staff come to you, falling to 50 staff come to you in the 9 years of your tenure to say, hold on, boss, we've been asked to fill out a document to say whether somebody is a Negroid type. I don't think that's really appropriate.
No.
What was the purpose of using identification codes for suspects and offenders?
I believe it's to do with official reporting to the police.
And how was official reporting to the police undertaken?
I can't recall.
Who was responsible for reporting to the police?
It would be the investigator who's in charge of the case.
And how were they to report to the police?
I have no idea.
What was the purpose of making a report to the police of the suspect's identification?
I have no idea.
At what stage in the process would they report to the police the suspect's identification code?
I have no idea. I don't have that level of operational detail.
If reporting to the police was the purpose of noting identification codes down for suspects, wouldn't one need to know what the police identification codes were rather than these post office ones?
That would make sense.
Can you think of any other purpose, if the purpose wasn't to report matters to the police, for recording a suspect's identity,
No,
i.e. their ethnic or racial origin?
no.
Were any statistics compiled of how many Siamese people were prosecuted, how many Negroid types were prosecuted, and how many Sicilian people were prosecuted?
No recollection of ever doing that.
Would there be any purpose in recording that information?
No.
When you saw this document, it therefore came as a complete surprise to you.
Yes.
Who was responsible for issuing case compliance instructions to the 100 falling to 50 staff?
Can I just clarify, when I talk about 100 down to 50 staff, that was across all the 5 strands, not just purely the fraud strand or the security operations strand, when you make reference to that number?
Okay, it's presumably a smaller number then.
Yes.
For those involved in fraud investigation and security operations, how many did you start with and how many did it fall to?
I'd say probably in the region of around about 60 to start off with. Towards the end, I will struggle to think because I merged 2 teams together, the preventative physical team with the fraud team to make the security ops, and there was an element of multi-skilling. So how many were actually left to do the investigation? I couldn't actually recall.
But that number, 60 at the beginning and then less than 60 at the end, who was responsible for issuing to them the kind of documents, the 3 documents that I have mentioned?
Yeah, that would have been down to the senior management of the security operations team.
And who was that in the relevant period?
What year we're talking?
We've got emails showing that this was in circulation between 2008 and 2012, and there was further circulation, I think, up until 2016, so really across your period of office.
Okay, I think I have listed it in my statement. So I think Dave Pardo,
Yes?
Ian Murphy,
Yes.
Rob King, and Amy Quirk.
And would they not come to you and say, look, boss, we're introducing this thing called case compliance. These are the things we're going to ask for compliance with. One of them is we require a particular font and line spacing. And you say to them, hold on, that's a bit petty, or that's a good idea, I like everything to be produced in the same font. Would they not come to you with things like that?
No, that's not the level of detail that I would be involved in.
Would they not tell you we're issuing case compliance requirements and auditing staff against them?
I may have been briefed at a one-to-one.
But the documents that I've shown you, the instructions on case file compilation, the Excel spreadsheet of case compliance scoring, and the identification codes document were all a surprise to you when you saw them recently?
Yes, they may have come across my desk at some point, but it's not documents that I'd actually get involved in because it's at a operational level that I would leave to the senior managers of the Strand.
So thank you. I'm about to move to a separate topic, and it's just coming up to 1. I wonder whether we might break until 2 o'clock.
Of course, yeah. I take it you're aware that you shouldn't speak to anyone about your evidence during the lunch break. Mr. Scott, I'm sure you probably don't want to, but If there are things that you would wish to speak to your lawyers about, then just let Mr. Beer know what you want to talk to them about, so he can decide whether anyone should make a decision about whether that's appropriate. All right.
Okay, thank you.
Thank you, sir. So 2 o'clock, please.